Hello. Welcome to the second in this series of podcasts concerning arbitration and alternative dispute resolution in the COVID-19 era. My name is Paul Cohen. This second of the podcasts, I am glad to say, is also co-sponsored by the Silicon Valley Arbitration and Mediation Center, of which, full disclosure, I am a member of the board of directors. So we have a lovely mix of people from both sides of that equation, 4-5 Grayson Square and the Silicon Valley Center, all of whom are extremely experienced and will contribute to a lively discussion. I am going to introduce them extremely briefly so that we can get on with this. This particular podcast is devoted to arbitration and also mediation, more specifically in the virtual context. So from the Silicon Valley Arbitration and Mediation Center, I have Duarte Enriquez from Victoria Associates. Duarte, if you could just raise your hand so we know who you are. There you go. Hopefully the names will show up in the recording, but I'm not entirely sure. Paul Mason. Paul is based in Miami and is it Rio or Sao Paulo?
Near Rio.
Rio, okay, fantastic. We also have Phil Engel, who is of the Atlanta International Arbitration Society. Welcome, Phil. On the Gray's Inn side here, we have Patrick Taylor. Patrick is the chap in the tie who's shown up just for the occasion. Good for you, Patrick. Colin Manning, with the impressive array of books or videos or something behind him. And of course, flying the flag as ever for 4-5 is Chris Baker. Chris, want to give us a wave? There you go. And last but certainly not least, Alex Sidosis, my partner in crime, who helps organize these podcasts. So chaps, I know the infirmities of Zoom make it difficult to jump in, but we'll try to jump in when and how we can. The first question is going to be, who among you has actually conducted a virtual mediation, either in this era or beforehand, that's entirely virtual? And I hear Mr. Mason and Mr. Taylor. So let's start with you, Paul, and then we'll go to Patrick.
This gray beard was gained for a reason. I was involved in the world's first video conference mediation in 2006 between a Brazilian party and a large US-based and multinational. And at that time, we didn't have laptops, we didn't have high-speed internet everywhere. What we had was video conference studios, which you had to rent time. It was quite expensive. And when we tried to reach people that didn't have great internet, it's tended to snow on the screen more than what we're used to, a lot more than what we're used to in Florida. But then we managed to hook up well 3 points, and we were able to get a settlement on the case. And that was a good experience. Now we're in a decentralized era. Everybody's got laptops at home, pretty good internet in most cities. We've got platforms like Zoom. There are other ones we'll discuss. Fast forward to today. Yesterday, I did my first video with counsel for a mediation about the sale of an aircraft, and it went very well by video. We used Zoom. One of the institutions who was administering mediation had the account, and the case manager ran the meeting. So it was a very positive experience.
Okay, thank you, Paul. So, and I'll ask you in a moment the comparison between then and now, which I think you've adverted to somewhat. Before we get to Patrick, I think Duarte had a comment.
Just a question to Paul. Did you have these caucus sessions with the parties, and how did it go?
In the first one back in 2006, we did have caucus sessions. It was the classic style. I sort of call it getting the S style. You have the opening meeting, and then you go to caucuses. That was the den. It worked. The only thing that didn't work in 2006 was a technical thing where one side could actually see the other side caucusing, you couldn't hear them. So we found that out afterward. You know, you could, and then then after doing a feedback about how it went, we found out, oh, you know, but nobody really gained a lot of information unless nobody had a professional lip reader or anything like that. And this one yesterday was just with council together so far. Then I'm, as I mentioned to Patrick and Colin and the group before we started recording, we're going to change the process because they have an entirely video mediation, which is what the parties actually requested, rather than the mediator or the institution. The parties wanted a quick one, they want a video. And because of that, as mediator, I felt that too much video can be tiring, and parties might have to be waiting around while the mediator is caucusing with the other side privately. So I arranged out the caucus first individually. Coming up quite shortly. I sent them each a set of 5 questions for their clients to ponder. And then I'm scheduling next week, early next week, individual private video sessions with each counsel and their client to get their perspective on the situation and what's bothering them, what they want, what their interests are, basic background things. And then after that, we'll schedule a joint session by video.
Okay, so in this particular modern one, you're having individual sessions, followed by group sessions, followed by individual sessions.
Well, yeah, because in mediation, unlike arbitration, there's certain differences between them, I'm sure we'll get to. But one of the differences is in mediation, it's quite necessary for the mediator to build rapport, gain the trust of all the parties. Arbitrators don't have to gain the trust of the parties. They have to gain the respect of the parties. Arbitrators are doing something completely different. Mediators are not rendering a legal decision and are not in that role. They're simply assisting the parties in their negotiations. There are various ways to do that. Some are more interventionist than others, but at the end of the day, parties decide what they want to do with it. Whereas arbitration, it's really a privatized legal process. It's more flexible and has certain advantages. But the role of the neutral is completely different. When I was a little kid, we had this joke. He said, what's similar about a cat and a giraffe? And the answer is neither one can drive a truck. And how this fits in, what's similar about arbitration mediation? Neither one of them is a court-run proceeding. You know, they're both alternative, even if they come out of a court case. So, and then people say, for most people in the street, the difference is arbitration is binding and mediation is not. But of course, that's oversimplified for.
And potentially, yes, I was going to say, not quite about to change, but about to be in a different context in the international sphere with the Singapore Convention. So binding, enforceable in that sense. You've summarized it very well, and I think we'll get to the idea of how arbitration and mediation are quite different, despite the fact that they are lumped in together as not the court, or alternative dispute resolution, ADR. But let's hear from Patrick and his experience with virtual mediation.
Yes, hi. I've done now 3 mediations in the last few weeks since COVID really hit England or Britain. I've done 2 by telephone, totally by telephone conference, and I've done another one by Zoom. So the technology has moved on as far as I see it, thinking about Paul's experience of 2006. So, but it's even accelerated within the last few weeks. I think as mediators, we've all had to learn very quickly how to use the technology. Telephones, of course, are easy to use in conferencing facilities, but Zoom and Microsoft Teams. And it's important to know how to use it, but also from that trust and confidence aspect that Paul was talking about, the parties really need to have confidence that we know what we're doing with the technology. And it was interesting also to hear Paul's experience of that slight problem where in the early days you could see one of the parties but not hear them, so largely confidentiality was preserved. Of course, confidentiality is a massive part of mediation. It's crucial to the role of a mediator to be able to have confidential discussions with each party, and for that party to believe rightly that those discussions are confidential. So it's really important, I think, for the parties to believe in the technology, but to believe in the mediator's ability with the technology as well, to know that we've got it right. Privately, I think it's something I worry about, and as Chambers 4 to 5 have practiced our skills with Zoom and other methods of online mediation to make sure that we've got it right, and that's really worth doing. The other thing that I found useful with the Zoom conference is that we organised what was, you might call it a caucus, with the parties a day or two before the mediation, but really what it was a dry run of the technology to make sure that the parties knew what was happening, and that their own facilities, their own technical facilities were up to it, that they'd got the necessary speeds. And in my experience, they work perfectly well. And all three of those mediations resulted in a settlement on the day. So certainly I was pleased with the outcome, and no major glitches. I think parties need to understand that they need to be patient, because some people are more familiar with the technology than others. But provided that's the case, then fine, and that they work very, very well.
Right, good to hear, and I'm glad you managed to settle virtually. I should add that we are recording this on the Zoom platform. The last podcast we recorded was actually on Blue Jeans, and it was what has now become fairly standard run through of how you do a virtual arbitration. So we tried Zoom, we tried WebEx, we tried Blue Jeans. I think we've had other experiences with MS Teams. I'm not sure we tried it on the day. I am curious to hear about some of the functionalities that people think are needed in the context of a virtual mediation, in terms of whether the Zoom chat room function is helpful to chat privately, whether the waiting room is useful so that you can stick the other parties back into a waiting room while you talk with others, for example. And whether anyone has experience with some of the other platforms and see if they can do similar things. And before I go on, I have to welcome Amrit Danoa, who is having technical difficulties. She's she's really our fearless leader on the mediation front. She's part of 4-5's mediation and arbitration groups, so she bridges that gap. Welcome, Amrit. Let me just show for the viewers what I'm talking about. I'm going to, actually I'm not going to do it with Amrit because of the technical difficulties. I'm going to see if I can get, for example, Alex back into the waiting room. Let's see. So Alex, excuse me, 1 second. Alex is now in the waiting room, and I will do the same just for fun with Duarte. Sorry, Duarte, I'm right back. Put in waiting room. I hope you can see this on the recording. So if you can see my recording, you'll see that Duarte and Alex are in the waiting room and off the screen. And so you can have, as it were, a discussion with one side, and then once you're ready, put the other side back in, and then do the same thing with the other side. So it allows that kind of private room functionality that you would have in the real world. I'm bringing Amrit and Duarte back. And I'm curious, Patrick, Sorry, not Amrit, Alex and Duarte, my bad. I'm curious, Patrick, is that the kind of functionality you used, or did you just sort of do a series of different calls, picking up and dropping off?
On the Zoom mediation, we used the breakout rooms, and you can set. You really need the Zoom Pro account, but if you've got that, you can preset. I think hundreds, but certain ample rooms anyway, so that you can allocate and pre-allocate rooms to a particular party 1, 2, 3, 4, 5, however many you've got. Plus an extra one, because you need to take time yourself as a mediator. So you need a room to come back to where you can do what you do during a mediation, really, which is to just take a bit of time to think and decide what you're going to do next. What have I just heard? What's my strategy for this? I haven't done a mediation on Teams, but I have used Teams, and I'm certain that the same technology exists in Teams as well.
It does.
I've just they supply virtual port or virtual wine in the breakout rooms for virtual media.
I don't think that happened in my mediation, but well, not that I could see. Maybe it happened when I was out of the room, but certainly the technology worked. I think we maybe had one minor glitch at one stage, and somebody had to dial back in, but it was good. But I repeat the comment I made before. You need to, as a mediator, you need to try to be as slick with that as you possibly can be, because the parties are expecting you to manage that. And they need to have confidence that in this technology, that when you're in that private discussion with them, that there's only them there, and nobody else can hear, so that they can impart that necessary information to enable you as the mediator to unlock the dispute.
I take it, Patrick, I have here the intermediate version of Zoom, so all I can do is stick people in the waiting room and back. But I take it that in the chat rooms, the parties can talk amongst themselves as they would in a private room.
Yes, I'm sure that is the case. Okay. I think maybe Chris can answer that, because I know he's represented parties in Zoom mediations. So he'll probably be better placed to answer that than I would. Chris, is that your experience from the Zoom mediations that you've been involved in?
Absolutely, it is. I mean, I'm a mediator and a practicing barrister, so I see it from as it were, both sides. The one virtual mediation I've been involved in so far was conducted on the Zoom platform. And I entirely agree with what Patrick was saying about the need, particularly if you're the mediator, to have everything set up well in advance and to be familiar with the technology. But I think it's also important, if one is going to persuade clients to engage in virtual mediation, that they have faith in the technology as well as in the mediator and are comfortable using it, because for many of them it will be an unfamiliar thing. So I think part of the hurdle, as it were, that everyone needs to get over is familiarity with how it all works. And often that's best done by having some sort of setup session or sessions in advance, so that everyone can see how it works. And the breakout rooms are, in my experience, confidential. One couldn't see the other people who weren't in the room. The mediator was able to come and go much as they would in a normal physical mediation. So confidentiality was preserved. There was a sense of privacy. I think doing it virtually has some other benefits, some of which are obvious. Clearly, travel is taken out of the equation. I think also doing it virtually is something of a leveler, because if people are conducting the mediation from the comfort of their own offices or homes, there isn't the same factor of intimidation, if I can put it that way, with physically being faced by an opposing team which seems very much more formidable than one's own, because on screen everyone seems much more the same. And I think that can be helpful in terms of getting things off to a good start. So my experience so far has been very positive. I think it is dependent on the skills of the mediator with the technology, and clearly it is also dependent on the technology working. And if one's going to run these things on a regular basis, I think it is important that backups be put in place in advance so that people can be contacted by mobile, by text, by email, and so on, just in case the main platform should fall over. So all in all, I would say it's very favourable at the moment. One qualification I think I would have is that I could foresee that if there were a lot of people involved in a mediation, either because there were a lot of different parties or because there were a lot of people on each of the sides, that might get quite difficult to manage from the mediator's point of view. And one of the features, I think, which we're going to see in a more virtual world, both for litigation and mediation, is that I think there's a greater inclination to be simple and to the point and to keep things short. Because the longer things go on from your desk on video, as I think we've already discussed, the more tiring it is. So I think there is an incentive from everyone's point of view to try and make things happen more quickly. But if there are a lot of people involved, then I think that is something that could confound that, make it quite difficult from the mediator's point of view. And one of the problems, obviously, in the mediation, if people are in separate rooms, is that there could be long periods of inactivity, which are quite difficult to handle. And there is then the risk that people may mentally, if not actually, switch off. I think the mediator needs to be quite careful that people don't start to leave the mediation without some prior discussion with the mediator.
I think there are a couple of...
a lot of thoughts. Sorry, go ahead, Paul, then I'll let Colin have a word after. Go ahead.
I was just going to say, there are a couple of ways to handle it. These are all very good points by Christopher. One thing you can do to reduce waiting time where people get bored and fidgety and look at their cell phones and all, as we discussed earlier, is to have some of the private sessions first before you bring the parties together. Meet the people privately, virtually first. Mediator can get more rapport with them that way and get basic information that will help him or her when the joint meeting starts. Another possibility, which I haven't seen discussed yet in the video context, is co-mediation. I've done some co-mediations, and if you have a large number of people, I had one mediation with, I think there were 12 participants. There were like 4 or 5 parties. There was insurance and reinsurance over an energy plant problem. And it was the ICC, and we succeeded in resolving. And at that time, we didn't have a co-mediator. I had an expert that helped with some of the technical issues, but no co-mediator. And I was thinking afterwards that I tried to think what could have gone better, even though it was resolved, that a co-mediation sometimes when you have a lot of people could work. And on a virtual platform, you have to work out, obviously, things very well with the co-mediator beforehand, have a separate breakout room with them, you know, so those are more details, but I think it's an option. And then coming to the advantages of, I think, especially now in this COVID-19, where there are a lot of companies that are cash strapped and they need to resolve things. Maybe the courts are closed, they can't get what they need there. Virtual mediation offers speed. You know, you don't have travel arrangements, as Christopher pointed out. It's a lot cheaper, especially for cash-strapped companies. That's going to be a good option. And also, besides speed, which tech companies especially like, putting on my Silicon Valley Arbitration Mediation Center hat, tech is often an industry where speed is prized to resolve things, to keep up with technological innovation, so that the parties don't fall behind, where all the competitors have leaped ahead and they're sitting there bogged down in court. So that's also, I think, a very helpful thing to consider.
Lots of good food for thought there, Chris and Paul. Thank you. Now, Colin, I take it that you haven't yet had the pleasure of doing a virtual mediation yet, but what are you looking forward to, if anything, and what are you dreading in this process? You'll have to unmute yourself, Colin.
I was behaving myself. One of the things I was going to mention actually was actually trying to persuade the parties to mute themselves to stop them interrupting others when they want to speak. We've had dry runs in chambers deliberately to prepare ourselves for this rush of mediations, which hasn't happened. We are getting quite a lot of inquiries now. I mean, I've had a number of inquiries. Only a few of them have turned into real mediations. I've got a couple next week and one the week after. So I'm interested in anybody's experience of the good and the bad. The dry runs are important because they focus one's mind on how you're going to have to adapt from the traditional form of face-to-face mediation to the virtual form. You mentioned, I think, before we actually were recording about the arms round shoulders, if that's actually allowed at all anymore or not, I doubt. But figuratively or otherwise, it's very difficult to get a kind of rapport with people on screen. How do you do it? So I think you're going to have to adapt personality. And I'm not sure myself how that's going to work, but we're all talking about getting the parties on board, both technologically and in terms of the actual dispute, so that you gain trust. Now that's going to be a skill, I think, that will develop over a period of time. I don't know whether I'll be successful at it or not. I hope I will, but I'm thinking of that. So that's why I think that this mediation that I've got next week, I'm going to have pre-mediation meetings for two reasons. One is to test the technology for all people who are involved, so they're happy with it and I'm happy with it. And also to actually use that time to actually get to know the people and to build that rapport. So that's the process I would want to put together. Then on the day, one will need to, or will be able to focus from an earlier time and use the time more effectively. That's what I hope will happen. And that's what I hope people will expect to happen. We'll see.
Okay, and are you using Zoom, by the way, or some other platform next week?
Using Zoom, and that's what we've practiced on. There are problems one has to be aware of with Zoom because they've had encryption problems, end-to-end encryption problems, which they say they've resolved with version 5.
They have.
And I don't think, yes, exactly. So I think that's another thing one has to be aware of in terms of actually warning the parties and from one's own protection as well, any liability.
Yeah, just FYI for anyone watching, the only reliable end-to-end encrypted platform right now appears to be WebEx. So if that's something you're worried about, then WebEx is your man or woman or platform or thing, whatever. Anyway, Alex, you had a comment.
Yeah, I've got a question. Just going back to something Chris said, that it could be a leveling field because you don't have that aspect of intimidation, for example, when you walk into the room and you see your opponent. But that seems to me can work the other way around as well. As a mediator, and in a mediator's role, you don't have the opportunity to walk into a room and see how a participant will react, or how they will react to a question you might ask a mediator, or to the offer made from the other side. And so just to those that have done a mediation virtually, and to Colin, for example, how he will prepare going into the mediation, how do you deal with that as a mediator when you're not in the room to read the other party's face, or to see how they're shaking their foot, for example, and kind of read the room?
Some people have suggested big wide screens, and they call it an owl camera, which is a 360. I think that's, you know, it's possible, but your point is well taken. I think, Alex, we can't have all the advantages of in-person. You know, there's always a trade-off. And that's one which, you know, you'd like to see the whole body language. You're absolutely right. Talking about negotiation, after all, and body language is in terms of interpreting people's reactions to your offer or whatever it is. That is something maybe several sessions can help with those kinds of things.
I think probably the question that we're coming around to is, what is the place for remote mediation in a few months' time, when hopefully we're in a situation that we could theoretically get back to normal mediation, whatever that is. My view, having done a few, is that I think that this is part of the mediation landscape now, and it will have its place, possibly because of the low value of a dispute. So there's economies of doing a mediation remotely, or because you've got parties who are spread across the world, and this enables us to get people together. I hope, however, it won't become the position in every mediation. I look forward to being able to, rightly or wrongly, Colin, put a hand on a shoulder, walk along a piece of land. I mean, the dispute that I dealt with most recently was a boundary dispute, and I know very well that at 3 o'clock I would have been walking across this farm with the parties, asking apparently stupid questions, but not really stupid questions, about why this problem couldn't be solved. And you're deprived of those kind of things in a remote mediation. But there are advantages and there are disadvantages, and it certainly fills the gap, and it's made us learn. So I think the good thing is we will be able to do it in future in appropriate cases. But for my part, I hope that we will be back to traditional mediations at some stage in the next few months. That's really where I come from.
I want to come back to that later because it is an interesting point. Sorry, but then Colin and Amrit had something to say as well. Go ahead, Colin.
Well, I think it may well be that there's going to be a kind of an amalgam of the face-to-face and the remote mediations in future. Sometimes because of distancing and saving in costs, that one party will be the other end of the country or the other end of the world. But there are some mediations where presence is actually important, but they'll have to be considered in circumstances of each dispute. But I think we're going to have to broaden the prospects of mediation and how it can be used. Perhaps that's going to be a good thing.
Amrit, go ahead.
Yes, just a few observations, really. I think, having heard a lot of your experiences, I think an important or a crucial theme in all of what we've been discussing in terms of dealing with these processes remotely is, I think, trust in the process itself. So for those who are parties using it and those who are acting as mediators or arbitrators, and I think if all of the people involved don't have the trust, it's unlikely to be successful. An important point I know that Alex rightly raised was in terms of, especially with mediation, I've always found it's a process that particularly thrives on, in-person contact, face-to-face. Perhaps that might be a first opportunity for parties who have been at complete loggerheads to be able to sit at a table across each other and actually talk about what's been happening. And I think mediation has always been able to do that quite well. And whether or not that can, in the same way, be dealt with effectively, albeit face-to-face but remotely, is, I think, a challenge that probably a lot of mediators are finding themselves in at the moment. But again, it goes back to the idea of trust, that if it can be done and we see more of it being used in the future and everybody getting comfortable with it, people will start to realize that it can be done just as well as being across a table from somebody. I know on the arbitration side, that in-person concern is also raised when people talk about examination of witnesses. So the classic cross-examination. How do you deal with that when you aren't in the same room and you're able to consider a witness's body language? And then you've got all the concerns that arise when you deal with that remotely. So who else may be in the room? Are they reading notes, on the computer whilst they're answering the questions? And these are, what people would consider some of probably the most pressing challenges at the moment. And whether those things inhibit the processes being used more frequently in the future, rather than just in this time as a temporary measure.
Just 2 points, if I might. One thing in mediation I usually do at least is try and get a round table when the parties meet. So they're in a more collaborative mode than sitting across each other from a rectangular table, which is more of an arbitration type of thing, or even a negotiation, face-to-face negotiation. A challenge to get a round table in a virtual mediation. I think that's not easy. So I'm agreeing with you, Amrit, about that. And as far as coaching and all, I think in arbitration, that's a very valid issue, and therefore virtual backgrounds are usually prohibited by the arbitrator. You have to be in the real. But in mediation, of course, people can talk with each other. It's a negotiation. So that issue doesn't come up in mediation, but in arbitration, certainly it does.
Has anyone here used telepresence? Are you familiar with Cisco telepresence? I mentioned this during the last podcast. Telepresence is sort of the high-end video conferencing. Cisco's offering, or WebEx is the lower end. And the problem with telepresence is you have to go to a special room, a special center in a particular city. But the advantage is that each room in each place is kitted out essentially identically. It's a big table, and a bunch of screens in front of you. And on the other side of those screens are the people from the other parts of the world logging in. And telepresence is a really high definition kind of video that makes it feel as though you are talking to the people literally across the table. Not cheap, but I wonder whether in long distance mediations it might be something that get some popularity in the sense that you will, to Alex's point, be able to see people's body language quite clearly, and it will shut down the distance. You still can't walk across the farm or whatever, but there you have it. Can I turn as we think about concluding this to the question of arbitration versus mediation, if you will, both forms of alternative dispute resolution. I think, subject to what Duarte and Paul and Amrit and others and Alex say, I think that video conferencing, video arbitrations are here to stay in many forms. And we have the jury's out on mediation, obviously. Do we see any advantage or disadvantage to one form of alternative dispute resolution over the other in this particular era and going forward when this era is over? Or are we just going to go back to the status quo ante? Arbitration will be arbitration, mediation will be mediation, never the twain shall meet. What do people think?
Don't they in fact cross borders where you've got MedArb, which may well actually be developed to a greater extent than has been the case, certainly in the UK. I know it's used much more in the States than it is in the UK, and I've done them. And they're very strange from the mediator's point of view. I don't like them particularly because if you mediate before you arbitrate, why would anybody, knowing you might be the arbitrator if the mediator fails, really open up to you at all? In fact, they've got every incentive not to. So I have very great concerns about that form of dispute resolution.
The US, they don't do that either. We have the same concerns. I think China is the only country that does that very actively, where you use the same neutral for old Confucian cultural reasons that would take forever to go into. But Germany, it's done in a modified way where I think sometimes where the arbitrator won't caucus privately, though. He just tries to, he or she will try and facilitate, but not caucus privately so as not to get any private confidential information that would affect their decision as an arbitrator. So I think China is a majority of one in this, what we call ARB-Med, where the arbitrator is the actual Med-Arb. I usually think of as a sequence where the parties could try mediation with a different neutral, and if that doesn't work, they could continue their arbitration or whatever. Or they could even do it during the arbitration without telling the arbitrator. They can go on. This has happened in some cases I've been involved in. I've either been the mediator on some of them, or I've been the arbitrator whose case was being mediated around the corner, which I didn't know about. So, that's possible as well.
One of the things I love about Zoom conferences, sorry, Alex, is that people can pop in at any moment. And so welcome to Brandon Malone of the Scottish Arbitration.
Hey, Brandon.
Hi. The hosts of ICA 2021 now.
No zooming on your kilt, Brandon.
He might be wearing his kilt. We don't know. I mean,
never know.
You don't need to demonstrate. Sorry, Alex, I was interrupting you. Go ahead, and then Amrit. From the perspective of someone who does both of these things, I'm curious as to your reactions.
No worries. Oh, welcome, Brandon. Nice to see you again. I was at a conference for international arbitration in New York last year, and it was a very interesting point where a lot of arbitrators were saying that nowadays, especially with big arbitrations, multinational, cross-border, a lot of money involved, what they do as part of their normal directions now is that they order parties to mediate. So go away, try start mediating this dispute, and if it doesn't work, then you can start the steps that are going to be very expensive and very time-consuming of disclosure, etc., etc. And I'm wondering, especially after what Patrick was saying, he can see mediation working virtual mediation, that is, working quite nicely, where you have parties scattered all over the world coming together virtually to mediate. I wonder if we might see more and more arbitrators actually ordering or directing parties to try a virtual mediation before they continue with virtual or in-person arbitration in the future.
It's very, very, very interesting. I wonder what, just an aside for the arbitrator types, do you feel you'd have the authority to do that? If I were a party, I might take exception, as I usually am, or counsel, I might take exception to an arbitrator ordering me to mediate. But what do you guys think?
Well, the way that that plays out in the jurisdiction in England and Wales is through costs. So a party that unreasonably refuses to mediate suffers possible sanctions in recoverable costs, regardless of whether they're successful. So that's the stick to beat a reluctant party to mediate. I'm not sure that whether or not to mediate before arbitrating really is a question of remote mediation. I think, first of all, I think they are two quite separate processes. So like Colin, I would be reluctant, I think, to get into a Med-Arb type situation. Mediation is a very different process, and it's perhaps now an even more appropriate process given the terrible consequences of COVID and the interruption to otherwise perfectly good business relationships. So the benefits of mediation being able to tackle the problems that we face immediately as a result of the current situation. And there's been some guidance published in this country, in England, as to what's called breathing space. And we can circulate a note on this, and that parties should really take the opportunity, ideally through mediation, to look at where they are now and to see whether or not anything can be done to preserve a contractual relationship or a relationship rather than getting straight into litigation. Or indeed, if the parties agree that because of the consequences of COVID, perhaps the relationship can't continue, to bring that relationship to an end on an equitable basis rather than the the terrible consequences of lengthy litigation, whether that's through arbitration or a court process. So I think that the time for mediation is now in many of those situations. And the obvious benefit to mediation is, as I think Paul talked about, is the speed with which it can be organised. I mean, I think now with remote mediation, we could certainly get a mediation running within a week, possibly less. So if you're facing that decision, do I terminate this arrangement, whether it's an aircraft lease or a building contract, then you can get that sorted very quickly and have the certainty of settlement.
Well, don't be too successful at that, though, because then us poor arbitration people will be out of something to do. Go ahead, Hamrit.
Yeah, I completely agree with what Patrick has said. I think when you're thinking about whether parties might be thinking any differently about whether to use arbitration or mediation, or perhaps a combination of the two, I think it will remain the case as it has been, that some cases and some disputes are just better suited to using one over the other. And there are, particular types of cases that will always find themselves lending to one or the other. So you'll have sort of the larger commercial disputes in construction or shipping that will find themselves using arbitration rather than mediation. And that's just how we've seen it. And I don't think that will change. What we are seeing because of COVID-19 is obviously there are now going to be massive delays in the court process. So those who might have already issued cases or may be issuing cases during this time and after now will find that there are going to be considerable waiting times to have cases dealt with. And so parties who have up until now been reluctant, even in small value cases, to look at mediation as a viable alternative will now probably see themselves using it for the very reason that Patrick explained, which is that they are looking for a speedy, quick way to see a resolution and to see justice, if it were. And that's whether or not mediation is going to be used remotely, or if we find ourselves doing mediations around a table. I just think that will now become an option that parties can see as being workable. I was involved in a case through litigation about 2 weeks ago now, where it was dealt with over the telephone, and the judge was looking at listing the hearing or the case for trial, and was looking at dates in November 2021. So I had a conversation with my client afterwards and said, it's important that you consider mediation and you consider speaking with the other side about that as an option, or at least considering it yourself more strongly than you may have done otherwise, especially if you're looking to have this dealt with at least before sort of 2022 or the end of next year. So I think it will be something that will perhaps, as I said, be looked at a lot more than it has been, and especially for a far wider ranging value of disputes than has perhaps been the case up until now.
I'd like to just come back. I mean, I think there will always be some cases which are not suitable for mediation. A case I have an involvement in at the moment, it involves suspicions of dishonesty on one party, and that perhaps is not suitable for mediation. But I don't think the complexity of the dispute is absolutely a reason not to mediate. It may in fact be a very good reason to mediate. And a lot of the standard clauses, for example, in the construction contracts, include high-level negotiation clauses as a tiered approach to solution to disputes. So I think that that is part of the process, and there won't be many disputes that mediation isn't suitable for, in my view.
I agree with that, and in fact, mediation anyway, from its inceptions in the mid-1990s, I think certainly as far as the UK is concerned, was at the beginning playing catch up, in the sense that people didn't know how mediation would be effective in order to, that the parties would actually trust the process to be effective to settle a dispute. I think over the 20 years or so that mediation has been around, certainly professional parties are perfectly well aware of the benefits of mediation and use it a lot. It doesn't matter how many parties, how much money or anything. I've done mediations with 10 and more parties and involving millions and millions of pounds. So I don't think that there's a catch up there. I think it's different that parties are now going to say, do I really want to have a mediation which is remote, for all the reasons we've discussed, the fact that you're not there in a room together? Or do I want to wait until a court hearing can be set up? I mean, as Patrick mentioned, it's the British Institute of International and Comparative Law who had a meeting and issued the concept note talking about a breathing space, which is really because of the pandemic effectively disenabling parties from completing their contract or fulfilling their obligations under a contract. And that leading to litigation, which is going to have to be dealt with, whether the contract's been frustrated or whatever. Added to the fact that you've got cases being adjourned. Certainly in the UK, a lot of cases are being adjourned, and the judges are very concerned about this because there's going to be a backlog. When the lockdown is lifted, there's going to be an enormous backlog of cases which the courts are going to find it very difficult to accommodate. As Amrit said, you've got a case being listed for November of next year. And that's just not going to be acceptable to the parties. So it's going to need the judiciary to actually make more trenchant comments about the need to use mediation in order to reduce that backlog. And that's really what I think the mediation community would hope for.
I think one other thing in the international arena, very quickly, is the Singapore Convention. And I think if that gets adopted by enough countries, the first day, 46 countries signed in Singapore, which is remarkable. The New York Convention was signed by 10 countries, 10 or 11 the first. There are now 52 countries. The minimum number to ratify it has already taken place so that it's going to actually come into force in September. This convention, for those people in the audience who may hear later recording, is one which basically calls for cross-border enforcement of mediated settlement agreements, international commercial mediated settlement agreements. And it's a little bit like the New York Convention for arbitration, but it's a lot easier because the Singapore Convention, when ratified, doesn't call for any reciprocity. It doesn't call for any recognition of the settlement agreement. You just have to prove, without even showing that the actual text of the agreement, there are ways to prove that it was mediated, that it was commercial. And the only effect of being a country that ratifies it is your courts will have to enforce it if the non-complying party has assets in your jurisdiction. But you can actually, the parties can negotiate the settlement agreement in the North Pole, and they can sign it on the South Pole. And, they can then take it, if one party doesn't comply with their obligations, they can take it to one of the signatory countries. And finally, most all the major countries from Asia have signed it. The US has signed it. A number of other countries, the Middle East, which is a lot of the trading world, these countries have signed it. The big hole is the EU, which has their own mediation scheme, and none of them signed it. But maybe one benefit, if there is one, well, I don't want to open a can of worms, but let's just say if and when the UK leaves the EU and when the government's attention gets beyond pandemic stage, that might increase the possibilities that one day the UK can also sign this agreement, the convention's treaty.
I'm sure it will.
That's a perfect segue, chaps, to wrap up with, I hope not too glib a question, but I was going to ask each of you in sort of 20 or 30 seconds or less, if you think that post-pandemic, post-vaccine, whether we will be looking at, Patrick has alluded to this, whether we will be looking at more of these international virtual mediations and if so, what their consequences will be for international dispute resolution generally. Let me start with Brandon, who hasn't even had a word in. So Brandon, go ahead, your first and last word.
I've been learning a lot, Phil. I think it's likely there will be more use of online, simply because people are used to the idea. I mean, many of us were using certainly telephone conference calls previously and some video conference calls, but we've all had this very steep learning curve. People are very used to the idea now. I think the character of an online hearing is different. You can get a very effective online hearing, whether it's mediation or arbitration. I think the character of an online hearing is different. I haven't personally conducted an online mediation yet, but I've conducted a few board meetings where I've been chairing board meetings of different organizations, and there is a different character to having everyone in the room. And there's some interesting additional functionality when you're doing it online. You know, you can have these rooms, breakout rooms. You can mute people, which can be an effective management tool from time to time. But it does have a very different dynamic, I think. And I think we may find that people really do like that and find it useful. And I think inevitably, now that people are used to the idea, the lower value claims, and lower value is obviously a relative term, but I think the lower value stuff, people will think, well, shouldn't we just do this online? Higher value, bigger claims where there's more at stake, people may still feel, well, I really want to be there. I really want to see the whites of their eyes and all the rest of it. But for lower value mediations and arbitrations where the cost can become disproportionate, this is certainly a way of reducing costs and speeding things up. So inevitably, I think there's going to be more of it.
Okay, yeah, well said, Brandon. Thank you. I'm going north in my gallery, which happens to take me to Paul Mason next. So Paul, your final thoughts?
Yeah, thank you very much for inviting me to participate. I think I agree with what everyone has said. Brandon's point about the mute button was good. One thing I would just add is, with both arbitration and mediation virtually, I do think there will be more. It also increases the possibility of selecting a neutral from a further geographic range of people, providing they're otherwise qualified according to what the parties want. I think I've seen, except for the very top cases, you know, 50 million and up, or maybe 30 million and up, whatever you want to call it, 100 million and up, where arbitrators are brought from around the world to hear those. There's a tendency I've noticed of arbitral centers to choose people that are close by, and sometimes counsel too. And with virtual, that's not so necessary anymore, providing the other basic qualifications are met. Thank you again very much.
Great points. Thanks, Paul. Mr. Manning, you are next on my screen.
Yeah, it was great to be part of this as well. It's very interesting. I think Brandon's got it right. But I think what we're more likely to see, I think, is a combination of in-person and remote within the same mediation. The whites of the eyes, I think, is important. Some people will feel it's more important than others. And other people are less important to the process and can be remote. I would just simply say that very often where you've got professional negligence kind of cases where you've got an insurer who insists on not being there, that is an extremely irritating factor in the mediation. You want the insurer there. At least if you can have him there remotely, that would be of assistance.
Thanks, Colin. Patrick, final thoughts?
He's muted.
You're still muted, Patrick.
Sorry. Lots of good points have been made. The way I would put it is the benefits of remote mediation as against face-to-face mediation. I love listening to records, and Fleetwood Mac is one of my favourites, but I'd much rather see them in concert.
Okay, you can go your own way, and others will go theirs. Sorry, I couldn't resist. Chris, go ahead.
It's been very useful and interesting listening to everyone. I'm sure we're going to do a lot more online, whether that's mediation, arbitration, or litigation. And I think one of the reasons why it's very useful to have this additional way of doing things is the convenience factor. And I'm sure that will be one reason why mediation in particular will have a lot to offer. Because as has been said, the ease and speed with which things can be set up is enormously useful. And once people are familiar with it, then we'll all feel much more comfortable about doing things in this way and dealing with them quickly.
Duarte, as a fellow arbitration but not mediation guy, what are your thoughts after hearing all this?
Yeah, as you said, mediation is not exactly my cup of tea. Not because I don't like it, but the idea, but because I still didn't get the time to study more deeply this subject. But I just have a final thought, which is connected with the trust that might be put at stake if these remote outlets are used more frequently in mediation as in arbitration. Whereas in arbitration, you have someone, and I'm speaking about the arbitrator, the decision maker, who is going to decide to make a decision whether the parties like or not. In mediation, that's not exactly the mindset. I believe that a mediator must be, most of all, a meeting of minds maker. So it must serve as a proxy so that the parties can have their meeting of minds and reach a settlement. I don't know to which extent these remote layouts will allow parties to rely, to gain trust and confidence on the person. Remember that more than any other ADR mechanism, mediation is a way of solving a dispute where the intuitus persona of the person who is mediating is more prominent than any other mechanism. So I don't know to which extent Zoom and other platforms can convey this necessary trust and confidence that parties must rely on this mediator.
Thanks, Duarte. Alex, as if I may, one of the younger generation compared to us old fogies, what do you think about the future of mediation in this remote world?
Well, first of all, I want to thank everyone for joining us, and it has been a very good conversation, and thank you for sharing all of your experiences. I think that coming, as you say, from perhaps a younger generation into the law in the past 3 years or so, I see especially here in England a bit of an apprehension about using technology in legal disputes generally. I think that in the past couple of months now with the pandemic, people have had to use it and have been pushed into using it perhaps. And this could be a good thing, creating a bit of trust around technology and seeing how it can actually work to our advantage. And all of the points that have been made very well about how quickly, for example, a mediation can be set up. And the discussion that we had about virtual arbitrations in our last podcast, Paul, we discussed how it can work there as well. So I am hoping that we will see a lot more virtual mediations and arbitrations going forward, bringing together more multinational disputes virtually, if you want, and if you may.
Thanks, Alex. Ms. Danaway, the last word is yours.
Thank you. My view is that we will see an increased appetite for dispute resolution, whether arbitration or mediation. I think that the pandemic has, as we've seen with the court system, it's sort of pushed the courts and the judiciary to sort of grapple with technology a lot more than they had previously done so. Some of the courts are still trying to get used to it, but I think what we'll see after this is whether or not the processes are used remotely or not. I think a lot of people will start to look at them, as I said, as viable alternatives, just because they won't see their day in court for a very long time if they want to pursue the litigation route. And I think, if anything, what the pandemic has done, unfortunately it's taken a pandemic, but it's shown people that it is possible, that these processes do work, and they can even be done remotely, which is an added advantage. So I think it's shone a spotlight onto these alternatives to litigation that I think were much needed for a long time, but it's unfortunate that the route with which it took to do that.
Thank you, Amrit. Thank you all. It remains for me just to say I've learned an enormous amount in the past hour or so, so I'm very grateful to you. I hope our viewers likewise have been stimulated by this discussion. Thank you again to the Silicon Valley Arbitration and Mediation Center for co-sponsoring this particular podcast, and you will find this podcast, among other places, on the center's fledgling YouTube channel. And stay tuned for more of the same from 4-5 Arbitration Group's series in alternative dispute resolution in the era of COVID-19. So thank you all, and see you soon.
Thank you.
Thank you.
Thank you all.
All right.